Case number 112523, State of Kansas v. Stacy Gensler. You may proceed.
Thank you, Your Honor. May it please the court, Ryan Gearing for Mr. Gensler. May I please reserve 3 minutes for rebuttal time?
3 minutes is granted.
Thank you, Your Honor. For the benefit of the people watching, what this case is about is Mr. Gensler was charged with a felony DUI in Sedgwick County, Kansas, a third offense DUI, and the state was relying on 2 prior convictions from the City of Wichita Municipal Court in order to elevate the classification and the penalties to the felony third offense DUI. And throughout the course of this case, Mr. Gensler has argued that due to the way that the ordinance is written in the City of Wichita and what the state law on DUI priors is, that those DUIs from the City of Wichita, the prior convictions, should not count as prior convictions, and therefore this should be a misdemeanor DUI. In the district court, the judge held that they did count as prior convictions. We appealed the matter to the Court of Appeals, which upheld the district court's ruling, and we have filed a petition for review, which was granted, and that's how we ended up here today. As far as the case itself goes, Your Honors, really the issue is that prior convictions in DUI cases only exist because they're created by a statute, and that statute is KSA 8-1567I. And in a case like what we have here with Mr. Gensler's case, when we're dealing with prior convictions from a municipal court, what the statute that defines prior conviction says is that ordinance of conviction from the municipal court must prohibit the acts that are prohibited by KSA 8-1567. And so what our argument is that the way that the municipal statute is written in the City of Wichita, the words are the same as the state statute. You have to basically operate or attempt to operate a vehicle while under the influence under one of the intoxication standards. The problem is that under the Wichita Municipal Ordinance, vehicle is defined much more broadly than it is under the state law. So human-powered vehicles such as bicycles and other things, you can get a DUI in the City of Wichita for doing those things, whereas under state law you could not get a DUI for doing those things.
But the statute 8-1567I says which prohibits the acts that this section prohibits.
Correct.
And the Wichita Muni Ordinance does prohibit all of the acts covered by 8-1567. It's just broader.
Right.
But if you look at strictly looking at the language, the Municipal Act does prohibit the acts that 8-1567 prohibits.
And I agree with that, Your Honor. It does prohibit all of the acts that are prohibited by the state law, the 8-1567. The
Why doesn't that just end the case then?
I don't believe so, because the municipal ordinance is broader. It encompasses more acts, and our position is that in order for it to be a prior conviction, it's got to prohibit the same acts, because.
But you just it sounded like you just conceded that that's not what the statute says.
If I did, that's not what I meant to do. If I did, I guess what my argument is that all of the acts under 8-1567 are also in the municipal ordinance, but there are more acts within the municipal ordinance that are not within KSA 8-1567, which creates a situation where a person could be convicted under the municipal ordinance for doing something that would not be prohibited by the state law.
What would prevent the legislature from declaring that kind of a conviction would count as a prior DUI?
Nothing, I suppose. If the legislature did that, then I think that's something that they could do.
And why isn't that what they did?
Well, I just don't think that is what they did. And what I would...
what could you point us to in the statutory language that would support
well,
that
I think
argument?
what I would point to is I think that the Hackett court, the City of Wichita, this court and City of Wichita Hackett addressed this And obviously that case was not about prior convictions per se, it was about whether the city of Wichita could home rule and include this stuff within their ordinance, and the court held that they could. But then the court discussed this and basically found that the legislative intent behind what the state had done was that we're only going to punish people for committing acts that are also prohibited by the state law, and that's why it's written that way. And we think that that's right, that that's what the intent was, and that's why it's important that when we get into an ordinance that has more acts that are prohibited, it doesn't prohibit the same acts. And I know that none of the cases that are cited in our briefs and whatnot, because they're all from the Court of Appeals, are binding on this court, but we think that basically all the panels of that court, but this one, got it right.
So we have to move to the constitutional question, in your view? We don't have any choice?
Well,
Or does Hackett carry the day for you?
when I read Hackett, I think Hackett's answered the question in our favor already, and basically holding that since the city put this in there, that they wouldn't be prior convictions under the state DUI law. I read Hackett to say that, and I understand that others don't read it the same way, but I think that that's what this court was talking about when it happened. And our first argument, obviously, is that since it's broader and doesn't encompass the same acts, that it's over right there and it's in our favor, that it doesn't prohibit the same acts, and we don't have to go any further. But
And you believe the basis for Hackett's declaration was statutory interpretation based on what the legislature intended priors to be?
that's what I understood Hackett to say, is that, well, what I thought Hackett said is, I think that this court identified this issue ahead of everyone else and said, yes, City of Wichita, you can add these broader definition of vehicles into your statute, but be warned that if you do that, you're going to have this problem with your prior convictions counting for state purposes. That's what I read Hackett to say, and I think the legislative intent that was determined is important for this issue also, for the reasons that I previously stated. So, like I said, that would be our first argument, is it doesn't prohibit the same acts. That should be the end of the analysis, and they should not be counted as prior convictions. But if the court does not agree with that, then obviously we have to get into the second kind of part of things, which is the fact-finding issue. And basically what happened in this case is the district court made a factual finding that Mr. Gensler was operating a motor vehicle, which would be something that was against the state law as well. And we think that finding of fact was made in violation of Mr. Gensler's rights. And
For that, it's DeCamp and Mathis and that
Yeah.
line.
yes, Your Honor.
Okay. This defendant, there are all these cases today, so forgive me if I'm getting them a little mixed up, but this was the one with the two priors. One arose out of what was originally a diversion. Is that right?
I don't remember for sure if one was
Okay.
a diversion or not. I know they both came from the city of Wichita, but I can't remember one was a diversion and one was a conviction or what.
But that was on a plea of NOLA, wasn't it?
Yes.
Okay. So you have yet a third argument, right?
I think they all kind of go together, but yes.
I mean, but it's a decision tree. I mean, it's can
Right.
we decide it on the statute and hack it or not. And if not, we move to the constitutional question. Then is it categorical or modified categorical? And if you apply both of those, where do you come out? I mean,
Right.
it's in order. So if I recall, the argument went, even if you get to modified categorical, this would be inappropriate because of
Right.
the NOLA.
Right. I think even if you get to where we can use the modified categorical approach, which I don't think we can in this case, then we're still, the district judge still made a finding of fact that had never been proven to a jury beyond a reasonable doubt, or had never been admitted by Mr. Gensler, since he did plead no contest in at least one of the prior cases. And I'm sorry, Your Honor, I can't remember if one was a diversion or what happened. I'm not sure that changes the analysis a whole lot, but to kind of go through the steps. Yes, this is exactly a Descamps, Mathis, Dickey issue, and to be fair, that when the Court of Appeals made the decision in this case, Mathis hadn't come out yet, so they didn't have the benefit of that. And I think Mathis really kind of shined the light on what we're talking about here as far as the alternatives within a means and things of that nature. So that's correct, Your Honor. We have to look, is this a categorical approach issue, or is this a modified categorical approach issue? And the first step in determining that is always to look at the ordinance that we're talking about and determine whether it's a divisible ordinance or not. Because if it's a divisible ordinance, then you can use the modified categorical approach, and if it's not a divisible ordinance, then you can't. So when you look at that municipal ordinance, in some instance, it is a divisible ordinance, but not really in a way that matters for what we're talking about, because you can get convicted of DUI under that ordinance for, say, having a DUI where you were .08 or greater, or you could get a DUI for being incapable of safely operating. Those are alternative ways of committing the offense of DUI.
But are they alternative elements?
Those, I would argue, are. But when we get to what we're talking about, which is the definition of vehicle within that ordinance, then I don't think that does make it divisible. And that's where the second step,
Okay.
that's the part of the Descamps and Dickey and Mathis analysis becomes important, because even if it is divisible, then you're supposed to go look at the individual subsections to determine, do any of these match? And when we do that...
Let me ask you, this doesn't fit real well into our typical alternative means or alternative facts, which is what Mathis was talking about. But if there were a vehicle that looked like a bicycle but was motorized, that could be used both ways or whatever, so that it was charged in Wichita Muni Court, would the jury have to be unanimous as to whether that vehicle was human powered or motorized powered in order to convict? And if
So we're in the municipal court?
Yes, you're in municipal court where it allows human-powered vehicles to be the conveyance that you can't drive under the influence. What I'm getting at is if it's an element, you have to have unanimity. If
Right.
it's just, there's different ways to do it, and there's different facts that could satisfy the element, which is what Mathis said.
Right.
Then Mathis says, well, the jury didn't have to be unanimous. But and that's one of the things they looked at to determine whether it's an alternative element or alternative fact.
And my response to that, Your Honor, would be that it's the latter. The city, I guess, would have to prove to the judge that the element is vehicle. Any sort of vehicle is going to be fine to meet the element. And that's what the situation we have with this ordinance. That's the problem with this ordinance is these are all just various factual mechanisms, I guess, to prove the one element. The element is always a vehicle. And that's why under the second step, we don't have anything that matches the state DUI law, so the modified categorical approach isn't appropriate. I think we fall back to the categorical approach. We look at the statute, we determine the statute is broader and doesn't encompass the same act, and that somebody could have been convicted for an act which, would not be violative of the state law, and we end up in the same place with an ordinance that doesn't prohibit the same acts. It's kind of a situation where no matter where we go with this, it seems that we always end up back in the same spot. And as Your Honor pointed out, even if we get to a point where the modified categorical approach can be applied, I just don't think it really makes any difference, because at the end of the day, we're still dealing with a judge that made a finding of fact, and that finding of fact increased both the classification and the penalties for Mr. Gensler, and it was a finding of fact which had never been proven to a jury or admitted by Mr. Gensler, given the no contest plea. And I see that I'm at 0, so I guess I should yield.
There was a
Questions?
question, Justice Stegall.
No, that's
Okay.
fine.
Any further questions? Thank you, counsel.
Thank you.
Good morning, Your Honors. Again, my name is Lance Gillette, Assistant District Attorney on behalf of the state of Kansas. In Mr. Gensler's case, I guess I will take the two issues as the state sees it in the same order that the questions came this morning. And the first would be the interpretation of 8-1567I. In that case, the operative clause of the statute that is, I guess, ripe for interpretation by this court today is whether or not a prior conviction will count, and it will if that prior conviction arose under an ordinance, quote, which prohibits the acts that this section prohibits. This is what I would, end quote, and this is what I would phrase as the state's plain language argument. We believe that under the plain language of that statute, then that the municipal court's ordinance in this case, since it did prohibit precisely the same acts and additional acts, that the fact that it prohibited additional acts is irrelevant.
So what if Mr. Gensler, for sake of argument, was convicted and he was was riding his bicycle that night, that he was convicted of a DUI? What effect would that have on that analysis? Doesn't matter?
I don't think that it matters under that plain language analysis. It should not matter.
It should count as a prior even though he was on a bicycle.
It should, and I think that that is a reasonable legislative intent argument to make here, and it's a reasonable
Even though it's not an
conclusion.
act that's prohibited by 8/1567 under the state statute.
Correct, and that's because the municipalities and local jurisdictions have the ability to prohibit, and this is part of Hackett. They can prohibit additional conduct, and that's okay. If they choose to prohibit additional conduct that is similar to, which is, I would argue, is what we have here, the city of Wichita has prohibited these bicycle DUIs or human-powered DUIs. What we're talking about is behavior that puts the operator or other people at risk on the roadways. As we saw in Hackett alone, that he wrecked his bike in the street and it required a police and an EMS response. These are very similar behaviors. I think it's reasonable that under 81567I, that the state would say, look, if you engage in similar behavior and you choose to do it again, we're going to penalize you for it.
But your analysis would allow that ordinance to also penalize walking under the influence.
I don't believe so, no.
Why? Because your
Because-
analysis is if the ordinance encompasses all of the prohibited acts of 81567, then if that's your argument that I understood it to be, then it doesn't matter how broad the municipal ordinance is.
In that instance, yes, the municipal ordinance in theory could be so broad and so wildly broad that it could loop in additional conduct, even, I mean, in
Well,
theory.
why is that different? I mean, why wouldn't your argument, if your argument is as you have described it, why wouldn't walking UI, I guess, also qualify as a prior under 1567?
Because walking under the influence is not prohibited under the subsection of Mr. Gensler's prior
Neither is
conviction.
biking.
Huh?
No, I
It-
think my colleague's question was, imagine it is.
Okay, if it
It's a
was.
hypothetical, yeah.
Yeah.
Imagine the ordinance also covers walking drunk.
Sure.
Would that also be a prior? Wouldn't that also be a prior under your interpretation of the statute?
It would be, yes.
Under 1567, you think the legislature's intention extended to walking drunk?
Assuming that hypothetical, only assuming that hypothetical, yes.
Well, that's what I'm asking you to do.
Yeah.
Go ahead.
And just along those same lines, you started to make a reasonableness argument. Why does reasonableness matter if we're really in plain language territory?
If we're looking purely at plain language, reasonableness doesn't matter. I think reasonableness only would come into play if legislative intent needed to be divined.
And if we're truly looking at plain language that is not ambiguous, we need look no further than the language of the statute, right?
That is correct. And the statute here.
Are there any other limitations on how broad the municipal ordinance could be under that plain language approach?
The limit is that the municipal ordinance, it has to be one ordinance because the defendant's prior has to have arisen under an ordinance, a single ordinance that prohibited the acts that this section prohibited. So in this instance, it would have been the municipal DUI ordinance from the Wichita Municipal Code. So that, I think, is the limitation. And I think that this is, I don't feel like I need to toe into reasonableness because, again, the Wichita Municipal Code does prohibit the acts that 81567 prohibits. But if there were some need to try to divine intent, again, I think that is reasonable, that to assume that a municipality would lump similar behavior together.
Well, let me push that even further than walking
Okay.
under the influence. What if the same ordinance prohibited littering? And, I mean, could a person convicted of tossing the bubblegum wrapper on the street be subject to having that counted as a prior DUI?
They could potentially.
So there's no, then that illustrates the answer to the earlier question. There's no limit
Correct.
to the arguably unreasonable nature of that interpretation.
Correct.
What about the absurd results doctrine? Do we get to that ever?
And I don't think we do. Again, my primary thing would be to rely on the plain language. But as far as reaching absurd results, I think it's fair that under the home rule statutes that municipalities can criminalize the same and additional conduct. I think it's also fair to indulge a presumption that they would lump similar conduct together rather than just some ad hoc throwing together, like just making one municipal ordinance and listing every possible crime underneath it. I don't think that ever happens.
But there is
Speak.
some outer limit to your plain language, isn't there? The absurd results doctrine would prevent the littering example, for example, spitting on the sidewalk, snoozing on a park bench.
Arguably, yes, that could. Again, if we need to divine legislative intent, yes.
And then what's your backup? What's your what evidence do we have of what the intent was here? There was a later amendment, right?
To the Wichita Municipal Code?
Yes.
Correct.
Does that tell us something about what the original intent was?
I think
Usually
that-
we would assume they're changing something when they change the language.
I think that it does. And what has happened is that the municipal code in Wichita has been amended. Bicycling, DUI on a bicycle or a human-powered vehicle is now a separate crime. It is still a crime. It's chargeable as a misdemeanor. It loses the gradation of punishments, but it is still a misdemeanor offense.
Is the new amendment just bicycles, or is it human-powered vehicles or whatever?
I believe it's human-powered vehicles, but I think the ordinance is titled bicycle DUI.
So why did that happen? Why did they amend to split it out?
The state believes that the reason that happened is that these two things are and have always been different elements, and that the city of Wichita has always treated them that way. And that goes, and I'll kind of get into that as I go through the Mathis argument here in a moment. But I think that evidence is not only that have they always treated them differently, but that they were sensitive to the fact that these cases were pending. This case in particular has been pending for some time. And they've seen these arguments being raised. They wanted to keep both separate, and therefore to avoid these types of arguments going forward, they clarified. Now, is it necessary that they did that? The state does not believe that it is, and that's where we get into Mathis.
Before you proceed to
Yes,
Mathis,
sir.
Hackett was a 2003 case, was it not?
It was.
What was the earliest that either the legislature or the city of Wichita changed either statute or an ordinance after Mathis?
I know the city of Wichita's ordinance did not change until 2016. The DUI law, the legislature changes almost every year. I can't tell you when the earliest after Hackett was. I'm sorry.
You're talking about the ordinance, though, aren't you?
Either one.
Yeah, the ordinance was amended in 2016.
And can anything be presumed from the fact that Wichita waited 13 years?
I think that it can be presumed that they didn't see this as a problem originally. It's not until these types of arguments arose when the United States Supreme Court issued discamps, and then this court started applying discamps and these modified and categorical approaches in Kansas, that there was a need, that they felt that there may be some ambiguity that they want to take care of. And I want to get to that ambiguity because ultimately, even if the plain language argument, the reasonableness arguments, even if all of that falls aside, all that the state has been asking the courts to do to this point is to simply use the tools that have been provided to us by the United States Supreme Court with Mathis. If this court will apply Mathis to the facts of this case and the laws in this case, then the defendant's priors count. I want to touch on one point to make it clear, because I think it's important that Mathis be read carefully. And the one thing I wanted to clarify is, Justice Johnson, as to one of your questions to opposing counsel this morning, whether we're talking about means versus elements, and that really is the question here. And I want to be clear that Mathis, in interpreting the Iowa statute, they used some language that is a little different than what we use here in Kansas.
Right, they talk about facts. I mean, they're pretty obsessed with facts. Once you're in fact land, you're done
Right.
under the constitutional rule.
Right.
They don't seem very twisted up on elements versus means, do they? It's different. It's a different analysis.
No, it's
They're
not.
saying once you have to ask about facts, you're done.
Once you have to ask about facts, you're done. But that's not a different analysis than what we go through here, and that's my point. They talk about what they refer to in Mathis as alternative means would be in Kansas options within a means. Those are the facts that we cannot go delving into. And what we're talking, and the other language they use in Mathis is they refer to different elements. And in Kansas, that would be our alternative means, because alternative means are different elements in Kansas. And so, understanding Mathis and then simply applying it to this case, what we have is the municipal ordinance definition of vehicle, and the question becomes, can we break this down without engaging in any kind of fact-finding? And the answer is yes. Mathis provides us with the tools that we need to do that. The first place that it tells us to look is to state law opinions interpreting the prior law.
Well, first you have to determine that the vehicle is somehow divisible, that it's something more than an element, don't you?
That's not correct, because
Okay, why?
because that's what the Mathis test is for, is to determine whether something is a fact or if it is an element. And we have to apply this test to root that out. That's the Mathis test. We first look to the interpretations of that prior law under state law. And here we have Hackett. And the state believes that the appropriate reading of Hackett in the language of the opinion itself exempts DUIs on human-powered vehicles from being counted as a prior conviction in subsequent state proceedings. It says nothing at all about DUIs in vehicles that meet the definition of state statute. Therefore, that gives this court a very strong indication that what we're talking about here is a divisible definition of vehicle. We have human-powered, and we have those that meet the definition of state statute. If it meets the definition of state statute, we're fine. We don't have to make any fact-finding. To the extent...
Don't you have to make a fact-finding to say it's a vehicle? Anytime you get into a definition, aren't you in fact-finding? You're past an element, you're to a definition.
To
The
that,
definition envelops, okay, here are the facts that define this element.
if that's the position, I would welcome that position. If that is the position that this court wants to take, then the state has to win this case. Because if the vehicle is a fact question, then the defendant has no basis to be objecting here. He can't try to delve into facts and then hide from the facts. And that was our initial argument in
I don't
this
understand.
case.
He's not trying to delve. He's saying that the judge went too far. The
He's
judge
telling
looked at too much information.
He
under
asked the
Mathis.
judge to look at the definition of vehicle. And so to Justice Luker's
Right.
question, if we
Because
start
that's
looking...
a legal matter. The definition of vehicle is a legal matter. It's set out in the statute and it's set out in the ordinance.
I think that it is. I'm trying...
So
Justice Luker...
this loops back to your first point,
Yes.
that it doesn't matter what type of vehicle, as long as it meets the element of the all-encompassing, whether it's littering or all the other things.
Or if just the elements match, which they do here. I'm saying if the question, as you posed it, Justice Luker, is if the definition of vehicle, if we start looking beyond the face of the ordinance of prohibited DUI at the definition of vehicle, if that becomes a fact question, then he has to lose, because he would have invited the district court to engage in looking at that fact question. And here it would have shown that in his priors, he operated a Ford truck and a Dodge truck. And if I could loop that back into the second step of Mathis, again, under Mathis, we look at state law. Hackett tells us this definition of vehicle under the Wichita Municipal Code, it appears to be divisible. If there's any ambiguity, the second step in Mathis is to take what they refer to as a peek at the charging document. They basically allow a extremely narrow factual glimpse to inform their legal conclusion as to whether or not an item is an element or a fact question. Here, in every one of these cases that has occurred in, I think that this court will see that the city of Wichita does not charge these crimes as operating a vehicle. They charge them all as operating a vehicle, and they say what type of vehicle explicitly. And in several of the cases, I know that Again, I'm going a little bit beyond the record just in this case, but I know the court is aware of all of them, given that these are all to get before you today. There's been found a number of times that never has anyone in Sedgwick County seen it charge just plain vehicle. The city always charges what type. And that tells the court that they treat this as an element.
How's this different under the Dickey analysis when we get into, or any burglary case where we have the dwelling, and the dwelling in the out-of-state conviction encompasses a greater, is broader than what the definition of dwelling in Kansas is? I mean, you're arguing that we can peek into that too, aren't you? Just look at the charging document. If it says a home or something like that, that would be sufficient?
No.
What's the difference?
The difference is, and this is again why we have to read Mathis, because they did exactly that, Justice Rosen. In Mathis, they looked at Iowa's burglary statute. Iowa's burglary statute defined the locational element as, I think, being a dwelling, business
broader,
building structure. It was extremely broad.
Right.
So the first step in Mathis is then look to state court opinions that interpret that. And when they did that, they found resoundingly that the Iowa Supreme Court had found that that was, in Kansas parlance, options within a means. And so you can't go any farther. You can't go looking any farther, because then it would have been required a factual investigation. And it stopped there, and that's fine. Here, it doesn't, because we have Hackett, and Hackett indicates these are alternative elements, alternative means, and then we can go further as need be. I see I'm out of time. If there are no further questions, I'm sure I'm going to be up here again.
It's muni court, so you wouldn't have a jury, but does the court have to find that, well, I don't know how you get to unanimity, but if the evidence is ambivalent as to whether it's human-powered or motorized, is that of no consequence if they're both covered by the municipal, or does the court have to find beyond a reasonable doubt which of those the state proved?
And I can't with 100% certainty answer your question. I can tell you I believe they have to find with certainty because of the way it's charged, and what we've seen in the factual findings, in the findings of some of these other cases, they have found that the city of Wichita charges these as alternatives.
But that's how it's charged, but would they have to under the ordinance? And that's what we're talking about, is what are the elements of the ordinance?
Right.
You know, we've got you charge narrow, you prove narrow, but that doesn't answer our question about are the elements of the ordinance broader?
And the elements of the ordinance are broader, but we can make that differentiation here. And we can definitively say, without violating Apprendi, without violating Discamps, without violating the defendant's rights, that the elements that his priors arose under would satisfy the state's definition of a vehicle.
Just out of curiosity, if
Sure.
you have a disabled pickup truck,
I'm sorry?
just out of curiosity, if you have a disabled pickup truck that
Okay.
stalls out in the middle of a lane, and so a bunch of sober people are pushing it, but the drunk's behind the wheel, is that human-powered or motor vehicle? A case for
That-
another day. Right?
That is a really good question. I'd
And would they have to prove it up in muni court, one way or the other?
I think that it would probably be a motorized vehicle, and I think that they would have to prove it up.
Okay, thanks.
Thank you, Your Honor.
Any more questions? Thank you, counsel.
Thank you, Your Honor. Assuming we get past that it's broader and we get into this whole fact-finding issue and things like that, I really think it's easier to kind of think of these things in examples. And I think the easiest way to think about this case and all these cases is that, for instance, if the Wichita Municipal Ordinance prohibited in Section A1 driving a motor vehicle under the influence, and Section B1 driving or riding a bicycle or human-powered vehicle under the influence, then we wouldn't be here today. because under Descamps and Dickey and Mathis, you could then go, look, this is a divisible statute, and when we go look at the elements, one of these matches, one of them doesn't. And if you're convicted of the one that matches, then it would be a prior conviction. But we don't have that because these are the bicycles or cars or whatever there is included within that definition of vehicle under the municipal ordinance simply create the options within the means that the element is just vehicle. Any one of those things is going to meet the element of vehicle. It doesn't matter which one, it can be any of them. The element is always vehicle, and there are options within the means. And the purpose, when you boil all these cases down, is I think we don't want to end up in a situation where we have situations where sometimes a violation of this ordinance is going to be a prior conviction, and sometimes it's not, depending on the facts of the case. And that's really the situation that we have. And what I would argue in response to the state's argument that Mathis allows a peek at the charging document in order to determine whether these are elements or not, I think it's pretty clear that this court has already held in State versus Brown that in Kansas, when we're talking about situations like this where we have various factual ways of committing a single element, that those are simply options within a means. They don't create any new elements. And since we don't have any new elements, any finding of fact as to what particular conveyance was used in a case like this is a finding of fact, and which takes us back into the violation of a Apprendi and a lien. It's that finding which is changing the classification of these DUIs from misdemeanors to felonies and increasing the minimum jail sentences and things of that nature. And we don't think that the court was allowed to do that.
Your equitable argument loses a little steam when you think about you can have two people, one who's both picked up on the same day. One's taken to district court and one's taken to muni court. One has a prior and one doesn't have a prior. You understand what I'm saying?
I'm sorry, I'm not following, Your Honor.
Well, you said you don't want the prior DUIs to apply sometimes and not to other people, but the same conduct can be a prior if it's prosecuted, because you can prosecute a DUI that occurs in Wichita. It can be prosecuted in state court.
Right.
And so it's whether it's a prior depends on which court the prosecutor takes it to.
I suppose you're right, Your Honor.
And so that's why your equitable argument is not compelling to me, because you're going to have, if we agree with you, then whether it's a prior depends on where law enforcement takes it, to which prosecutor's office and which a court it's filed in.
Well, I guess my answer to that would be, I guess it would more depend on who you were pulled over by than where. I mean, the prosecutor's gonna charge the case in municipal court if it's a Wichita police officer that pulled him over and it's not otherwise a felony.
Does the ordinance's amendment make all of these cases last impression? Your argument's gonna go away, right? In future
Well,
muni court?
for anything that happened after the date of the amendment, yeah, I agree
Yeah,
with
that's
that,
what I
because
mean.
they're not, I mean,
there might be other cases covered by your rule that are still pending on appeal or whatever, but after that, once the cases started being prosecuted after the amendment.
right, any
this
convictions
case-
that happened in the municipal court after the amendment, I don't think this argument would exist.
Yeah, okay. Thank you.
Thank you.
Any more questions? Thank you, counsel. We appreciate the arguments by both counsel today. Court will take this matter under advisement.